The hearing began with the judge asking why the plaintiff wanted to evict the defendants. The property owner explained that the individuals simply showed up and started living in the house without permission. She stated that several people were staying there and causing damage to the property. According to her, the house was being filled with junk and unnecessary items. She also claimed they were going through neighbors' garages and even searching a maintenance worker's truck. The judge asked whether there had ever been a lease agreement between the parties. The response was clear: there was no written lease. The court then focused on how the defendants gained access to the property. The owner suggested that her nephew, who had personal struggles, may have allowed them inside by leaving the door open.
What's the reason you're seeking to evict the defendants?
The guy just showed up, started staying. Got a handful of people that are just staying at the house and tearing up my house, filling it full of crap, rummaging through the neighbors' garages, rummaging through the maintenance guy's truck that I sent over there to, just troubles.
Miss Acosta.
Yes. Sorry.
Did the plaintiff have a lease with the defendant at any point?
Nope.
No lease. All right. Do you know how the defendant came to have possession of the property?
My nephew, who is...
The judge clarified the situation to determine whether the defendants were squatters or tenants. The plaintiff insisted that there had never been a formal lease. However, she admitted that her mother told one of the defendants he could stay if he paid $400 per month to help with utilities. She confirmed that in November or early December, $200 was paid. The judge immediately pointed out that accepting rent creates a lease agreement, even if it is verbal. This shifted the legal position of the case. The court explained that once money is accepted for rent, the occupants are no longer considered random trespassers. Instead, they are tenants under a verbal lease. That distinction became central to the case.
He's troubled. He has mental issues. He's been in prison. My parents put him in one of their houses.
Ms. Acosta, I don't care about your nephew's history. I just need to know how did the defendant get into the property?
They just showed up. They just showed up. They met Brandon on the street and they just showed up. I mean, from what I gather from my nephew and from them, they just showed up and started staying.
So your nephew is who gave them access?
I guess, Judge, he leaves the door open, so whoever wants to come in comes in. I can't get him. We're going to get him out as well.
Okay, so Ms. Acosta, if I understand correctly, what you're saying on behalf of the plaintiff is that the defendants are not tenants and they've never had a lease.
They have never had a lease. I think in November or December, because they were just staying there. More people were showing up. My mom did tell him that if he wanted to stay, that he could pay $400. That would at least pay for the utilities. And I think in November or the beginning of December, he gave Mom $200. And that has been it.
Well, now that's a lease.
Okay.
Right. So let's get the story accurate.
The judge asked when the defendants first began staying at the property. The timeline suggested it was around October or November. The plaintiff confirmed that she had told them multiple times to leave. Despite those instructions, they continued staying at the house. Eventually, she agreed to accept $400 per month in rent. The defendant only paid $200 instead of the full amount. The court made it clear that agreeing to monthly rent establishes a landlord-tenant relationship. Even without paperwork, a verbal rental agreement is legally binding. Therefore, the issue was no longer about trespassing, but about unpaid rent under a lease.
Any sort of emotional story, right? The defendants at some point came over and began staying at a unit that is owned by Miss Acosta, correct?
Yes.
Does Miss Acosta live there too?
Nope.
Okay, so this is a completely separate place from her.
Yes.
All right. Now, when, to your knowledge, or does Miss Acosta know, when did the defendants first come and start staying at this property?
When did they start staying? Like November?
Probably in October, November.
October, November.
All right, sometime in October. All right. Now, did Miss Acosta tell them to leave?
Yes.
Lots of times.
In October, did you tell them you don't have permission to be here?
Yes.
Yes.
Okay, and they stayed.
Yes.
Did there come a point where you agreed to accept money for rent?
Well, in December, he gave me 200. But he kept telling me that he was gonna pay and that he was gonna pay and this and that, and he just
What was
got
he gonna, Ms. Acosta, what was he gonna pay?
400 a month.
So that was the agreement for rent.
Yes.
Then that's a lease. Got
Okay.
it. Have a lease. So they're not squatters. They're not just random people. You knew they moved in and then you agreed to let them stay for $400 a month. If you didn't pay, that's a different story. Okay. So we have a lease with an agreement of $400 per month. All right, Ms. Acosta, after y'all agreed that he could pay $400 a month, did he pay $400?
No,
How much did he pay?
200
And when was that?
in December.
January 2nd.
No, it wasn't
Mr.
January.
Jimenez,
Sorry,
you
I'm
need to speak out loud.
sorry.
I'll be honest, you telling me you paid in January does not help your situation.
I know that, ma'am. Sorry about
All
that.
right, so just be quiet. Ms. Acosta.
The discussion moved to the notice to vacate. The plaintiff confirmed she served a Texas notice to quit on January 3rd. The notice gave the defendants 3 days to either pay the full rent or vacate the property. The judge reviewed the wording, which clearly stated pay or vacate. The court asked whether full payment was made within that deadline. The plaintiff said no payment was received in full. The defendants, however, claimed they attempted to pay. They argued they had tried to arrange payment and were willing to settle the balance. This created a dispute about whether payment was properly offered.
You said he gave you $200 in December?
Yes.
All right, so he agreed in November to pay $400, but did not. And then
No.
in December, he only gave you half the rent.
Yes.
Who gave you the $200? Was it Mr. Jimenez or his counterpart?
No, he's Mr. Jimenez.
So he gave you $200, but his roommate didn't give you anything.
No, nothing. Not a nickel.
All right, only paid $200. How about January? Has any rent been given to you for the month of January, Ms. Acosta?
No.
All right. Did you give them a notice to vacate?
Yes.
When was that?
Served Jimenez on January the 3rd. That's when I took the Texas notice to quit. And then we went to the court the following week and filed with the court. And then the constable served him.
Ms. Acosta, the notice to vacate that you provided the defendants, did it give them an opportunity to pay and cure?
Let me see. Yes, we asked for $400 and if payment was not made within 3 days, and that was on January the 3rd.
All right. I'm gonna just share my screen to see this notice to quit. To Joseph Jimenez dated January 3rd, in accordance with the laws of the state of Texas, within 3 days of service, either paid cash to the undersigned landlord against the back due rentee. If payment is not made, you will be required to quit and deliver up the premises. All right, so pay or vacate. And Ms. Acosta, did the defendant make payment in full?
No. No.
All right, Mr. Jimenez.
One of the defendants explained that there had been a verbal agreement. He claimed they performed remodeling work, including repainting and kitchen improvements, as part of their arrangement. According to him, this labor was supposed to offset some of the rent owed. He stated that $200 was given and that further payment was expected in early January. However, shortly after that partial payment, they were served with the eviction notice. The judge focused strictly on whether the full rent was paid by the deadline. The defendant admitted that it was not fully paid. From a legal perspective, failing to pay within the notice period weakens the tenant's defense.
Yes, ma'am.
Good afternoon, sir.
Good afternoon.
Thank you for being here. I understand Mr. Chandler's not here.
All right.
All right, Ms. Acosta, after we've had a little bit of conversation, understand that it sounds like you and Mr. Chandler entered into a lease with Ms. Acosta for her premises at the rate of
Hello.
$400 a month. Is that correct?
Yes, ma'am.
Hello,
December the 1st.
Mr. Chandler is here.
Mr. Chandler, are you here?
I'm here. I just couldn't be able to speak. I just found out how to unmute.
Oh, wonderful. Well, welcome. Good afternoon to you as well.
Thank
All
you.
right. Mr. Chandler, Mr. Jimenez, is it correct that y'all had a lease and under the lease, the rent was $400 a month?
Ma'am. We came
Yes,
up with a verbal agreement where that paid up until halfway through December, because we performed we remodeled the kitchen, painted everything, repainted, prepped, painted everything. And then we agreed that it would, for me and Chandler, it would pay up until the halfway through the December. And then during that agreement, agreed that we would be painting the living room as well to pay for the rest of the year. And then on January 2nd is when that $400 payment would be due. And then January 2nd, I gave him 200. Next day, I was served a notice to quit.
All right. That's exactly as expected, right? So rent wasn't paid in full. They said, hey, pay or leave. Did y'all
Yeah.
finish paying off the rent?
I can. I have
Yes,
lists.
I was also, I'm sorry.
But
I
the answer is
I
no.
also-
Y'all did not pay or vacate by the deadline given in the letter.
Yeah, well, I was also filed on. They filed.
The defendants argued that they attempted to make full payment on the final day, but were refused. They claimed the landlord told them not to worry about paying because eviction was already in motion. The landlord denied ever refusing payment. The judge asked for proof, such as receipts or messages confirming the attempt. A text message was mentioned, but it did not clearly show the date of payment. The court emphasized that verbal claims are not enough without evidence. The key question remained whether rent was placed in the landlord's hands before the deadline expired.
On the third day, I tried to actually give them payment, but they wouldn't.
Yeah, I did the same, and I said I had the whole payment, and then they also said that to keep your money, don't worry about it. We're gonna get you out of here, and that was it. I mean,
All right, Ms. Acosta. Both
Yes, ma'am.
defendants say that they came on the final day to make payment in full and that you refused to accept payment. Is that correct?
No, ma'am. They never have offered to pay in full. Never.
no,
All right.
They're full of excuses.
I have.
no, you did
Mr.
say that. I'm
Chandler?
sorry.
Mr.
No.
Chandler.
Chandler,
Ms. Acosta?
yes,
Bias. Mr. Chandler? Did
Yes,
you have
ma'am.
any proof that you attempted to make payment before the deadline?
Yeah, I'll also, by my notes, but that same day, I mean, Joseph was there as well. I mean, the witness was there. I even told Brandon. I mean, I tried talking to him. I also tried meeting them outside the house, and and we were supposed to meet at a certain time, and they chose to go to the house first. You know what I'm saying? And after we had a meeting that we were supposed to meet at 2:00 at my job. At my job. So that's why I was going to give him the payment on it. And I told him I have the full payment. She said, "Don't worry about it. You're getting to me." She just cut it short. And then
Mr.
also,
Chandler, Mr.
yes,
Chandler,
ma'am.
if what you're saying to me is that they could have come up to my job and got the payment for the rent that I was already late on, that's not a defense here. Did you get the money in their hand by the end of the day?
Yeah, she told me.
The dispute continued over whether $200 was paid in December or January. Under oath, the defendant insisted he paid on January 2nd in cash. The landlord maintained it was paid earlier in December. A witness confirmed sending a message acknowledging receipt of $200, but no exact date was specified. The judge carefully evaluated the timeline. Ultimately, the exact date of the partial payment became less important than the notice timing. What mattered most was whether the eviction lawsuit was filed correctly under Texas law.
Keep your money. Don't worry about it. She said.
And the answer
I
is
promise
no.
you. Well, do because of what she said.
Ms. Acosta, did he call and arrange to make payment with you? Did you tell him to keep his money?
no,
No,
he
ma'am.
hasn't paid a nickel.
Well, no.
No rent was paid for January?
Nope.
And I'm sorry. Then we also agreed that we was going to pay $100 a month.
A week.
A week. I'm sorry. $100 a week. I'm sorry.
Okay, all right. Mr. Jimenez,
Yes,
Mr.
ma'am.
Chandler, did either of you pay $100 January 1st?
The payment was due on the 2nd, and I paid him $200 on the 2nd. I would be technically $100.
Mr. Jimenez, Mr. Jimenez, Mr. Jimenez.
Yes,
You
ma'am.
said you paid rent January 2nd?
Yes, ma'am.
How did you make that payment?
It was cash payment
Who'd you give the cash to?
to Miss Rafaelita.
Who's that?
That's Miss Acosta.
Owner,
In red, Ms. Acosta?
ma'am.
Yes,
I'm identifying her, that's in red.
yes,
Ms. Acosta, Mr. Jimenez, under oath, is telling me that he gave you $200 on January 2nd. Did you receive money from him January 2nd?
it was in December.
Mr. Jimenez, is there a chance that there's a confusion between you?
I don't confuse money or numbers.
What proof do you have?
I
Can you
have
tell me the description of how it happened on the second?
as of that date to show that date.
Yeah, like how'd you pay her on the second? Did you give her cash? Did you give her a check?
Here cash, but the only I asked for a receipt as well, and I just got a text message just to confirm that.
Do you have a text message?
I think I have it from Miss Diane, their aunt.
Who's Miss Diane?
That's me.
All right, Miss
Yeah, and
Pam?
he had
Ma'am?
asked me to send it to him. I sent it to him. I don't know what day I sent him.
Listen, what did you send him?
I think when he asked me to, I just tell him that yes, that he had given mom $200, but I didn't put down the date because I didn't know what date he'd given it. One of the days that I went to the house to check.
Okay.
I have
right.
a text message that says received $200. It was dated January 3rd, the day after when I was served the notice to
No.
quit.
Nope.
Okay.
I have a text message from you.
Y'all, ultimately, when I look at these things, Ms. Acosta, I'm afraid it's going to be a judgment for the defendant, and here's a reason, and you're not going to like it. Your notice to vacate, you filed one day too soon.
Too early.
That's 100% correct. Mr. Jimenez raised that issue, and he's right. The notice to vacate, I'm going to say that it's valid because it tells him to pay or vacate, right? But you gave him 3 days, and the third day would have ended at the end of the 6th. You can't file it on that date. You filed one day too soon. So keep that in mind if you wish to pursue this again against Mr. Chandler.
The judge delivered a crucial ruling regarding procedure. Although the notice itself was valid, the landlord filed the eviction lawsuit one day too early. Under Texas law, tenants must be given the full 3-day period to comply. The landlord filed on the 3rd day instead of waiting until the period fully expired. Because of this timing error, the case could not proceed. The judge explained that this was a technical but critical legal mistake. Even though rent was unpaid, the improper timing required dismissal. The landlord was advised to refile correctly if she wished to pursue eviction again.
Mr. Jimenez, assuming that things don't otherwise work out. Also, be very important, y'all. This is for all parties. The timing is very different now. You cannot include the day you send it, and if it ends on a Saturday or a holiday, they get an extra time. So
Okay.
this is a huge change.
Judge, I do have a deal. Judge, we served Chandler on the 31st. That guy has never paid a penny of the $400 for his room rent. So it's why is he protected?
Because the statute requires that you give them 3 days. And so when you gave him that notice, it ended on the end of the 6th. You can't file the suit the same day. You had to file on the 7th.
Okay, but
timing issue, Ms. Acosta. And
is that for Chandler since he was served on the 31st?
No, it's for both of them. You filed the lawsuit 1 day too soon, and there's no way to cure that.
Even for Chandler?
Correct, because they both had the same lease. You both gave them the same notice to vacate. You cannot distinguish between the two. They are one and the same.
Okay.
You
all right.
absolutely can do this again. Please go and take a look at the new laws though regarding giving notice, what you need to do for that. And then Mr. Jimenez, Mr. Chandler, if you move, you'll avoid an eviction potentially. But you can also talk to Ms. Acosta. Maybe I'll come up with some new agreement. All right.
So as far as payment, if they decided to accept, should we accept that agreement?
I can't give you that. That sounds
Okay.
like legal advice, right?
Okay, no worries.
Y'all, best of luck to all parties. Please
Judge,
check our website, okay?
Judge.
Yes,
A second eviction case was introduced involving significant property damage. The landlord stated the tenant had lived in the home for over 2 years. During a walkthrough, they discovered missing bedroom doors, damaged cabinets, hammer marks on the front door, and large amounts of trash in the yard. The landlord provided notice on December 16th demanding either an additional deposit or that the tenant vacate. The tenant did not leave, leading to the filing of the case. The court confirmed the notice was properly delivered and received.
Judge, what should I do about all of the stuff that they bring into the house and into the yard that, they have a ton of bike frames. They take the tires
Ms.
off.
Acosta, I can't answer that. That would literally be legal advice as to how you might take action against a tenant.
Okay.
Please contact the apartment association. they probably
It's-
have some information.
It's not an apartment, it's a home.
I know that, but they have a lot of information on their website about renting in general that might be useful to you. Okay, any and all landlord agencies.
Okay, I will go file more paperwork. Thank you.
All right, good luck to everyone. I really
Yep.
appreciate it. Thank you all very, very much.
Thank you,
Y'all
ma'am.
have a better day. Okay, thank you.
Have a good day.
All right.
The case was filed because the tenant had lived there just over 2 years, and upon doing a walkthrough, we've just noticed excessive damage to the home. We've had several complaints of nearbys, what caused us to do the walkthrough. And during the walkthrough, all the doors, bedroom doors were missing. Massive damage to the front door, hammer marks all over it. Kitchen cabinets, drawers were broken. A backyard is full of trash. And I have some pictures here that I can show of when they moved in to what it is now, if you want to see some of those.
That's all right. Did you give a notice to the defendant?
Yes, we did.
All right. What day was that?
The notice was
Mr. Mangione, when I take a look at what you provided at the time of the filing, there's a notice to vacate. It was dated December 16th. Did we just lose him?
I don't know what happened there. I think I lost the connection. Sorry about that.
That's all right. We were asking about the date you sent the notice to vacate.
It was December 16th. It was received on December 17th, proof of delivery.
Okay. Right, and after the terms in the notice to vacate, what were the provisions?
It was just saying that, we need an additional deposit or for her to vacate the property. Just because of the excessive damage, and there was no payment and she never vacated. So we just followed through with filing.
All right. Good afternoon, Ms. Roman. Thank you for being with us.
Yes, ma'am. Hi, how are you doing?
Oh, computer fun. All right. Mr. Mangione says that this case is related to lease violations, to wit, damage to the property. He says that upon inspection, they discovered quite a few things that have doors missing, broken cabinets, some excessive trash, and that they provided you with a notice to vacate or to provide an additional deposit on December 16th. Is that correct, Ms. Roman?
Yes, ma'am.
All right. And then how would you respond to that?
When I have me and my spouse, we were living here, and I recently got into a domestic abusive relationship. And I also have the case number to where he's the one who did all the damages to the property. And I know they had told me that if I don't move out when he moves out, that I was going to get charged with it. But I feel like that's not right if he's the one who did all the damages. And right now I'm dealing with the crime victim. Yeah, I'm dealing with them right now.
All right, Ms.
But-
Roman, have you received a permanent protective order from the county?
There is a protective order. It was
Is it
an
a permanent protective order or is it a temporary?
right now it's an emergency protective order.
Okay, that wouldn't count then. All right, Ms. Roman, it may very well be the situation that someone who was in the apartment with you caused that damage. Unfortunately, the lease makes you equally responsible for it. And that would not be a defense for that kind of notice or for that type of damage that's occurred. It sounds like it's correct that the damage occurred, albeit not because of you, because of someone else, but that did happen.
Yes, ma'am.
All right. Well, it'd be a judgment for the plaintiff then for violations of the lease, to wit, that kind of excessive damage. Mr. Mangione, though, today are you just seeking, rent is not an issue, it's about possession?
It is, Your Honor.
All right. Under the lease, what is the monthly rent?
I believe it's 1875.
Ms. Roman, is that correct? Is it 1875?
Yes, ma'am.
Okay, that's what I would put the appeal bond at then. Ms. Roman, we'll send you information today. Again, if you have 5 days to take an appeal, don't do anything. That day 6 is the soonest the landlord could take some action. And if you are still working through with your emergency protective order, let them know what's going on. That may have some impact, or it may change some of the ways in which you're pursuing that. Okay?
Okay, so what's gonna happen now? What do I need to do?
Well, that's a loaded question. I'll say that from a legal to court perspective, now that the judgment's been entered, after 5 days, beginning tomorrow, if you don't take any action, if Mr. Mangione's if the plaintiff doesn't do anything, that judgment becomes final. And on day 6, that is when the landlord can have a writ of possession. They can come to me or writ of possession. And if you have not yet moved out, they could remove you, your partner, and your items. But they cannot do anything for at least 5 more days.
Okay, and then also I was wondering with the eviction, can that come off of my record? Because I know it's
Currently in
gonna,
Texas, there's no method under Texas law for an eviction to be removed from your civil history filing. If in the next 5 days, you and the landlord come to some agreement, the landlord can ask me to set it aside, but that is wholly at the plaintiff's discretion. That's their option. Okay?
okay.
Those
So
are
right now,
great
I gotta
questions.
file an appeal?
You have that option. We will email you and Mr. Mangione all that information.
Okay, thank you so much, ma'am.
Good luck to you, Mr. Roman. I hope you find yourself in a safer situation. All right,
Yes,
Mr.
ma'am.
Mangione, thank you for your time.
Thank
Court will enter that information.
Thank you.
Thank you all.
The tenant responded by explaining she had been in a domestic abuse situation and that her partner caused the damage. She stated there was an emergency protective order in place. The judge expressed sympathy, but explained that under the lease, all tenants are equally responsible for property damage. Since the damage occurred, it constituted a lease violation. The court ruled in favor of the landlord for possession of the property. The tenant was informed she had 5 days to appeal. The judge also clarified that, under Texas law, evictions generally remain on record unless both parties agree to set it aside. The hearing concluded with guidance for both sides on their legal options moving forward.